Hello viewers, I am Professor Sharanjeet, working at the Rajiv Gandhi National University of Law, Punjab. In today's lecture, we shall discuss the role and responsibilities of Central Consumer Protection Authority. The Consumer Protection Act 1986 paved the way for a robust legislative ecosystem for protecting the rights of vulnerable consumers of our country. This was comprehensive legislation dealing with different aspects of consumer rights, consumer protection, and redressal of grievances. Keeping in mind the growing economies and ever increasing markets, particularly by the introduction of online markets, the consumer protection law has been amended from time to time and was replaced by the Consumer Protection Act of 2019. In today's lecture, we shall discuss the role and responsibility of the Central Consumer Protection Authority in India, also known as the Central Authority. Objectives of the Central Consumer Protection Authority. Dear viewers, the central government has been empowered to establish by a notification a Central Consumer Protection Authority to regulate the matters relating to violation of rights of consumers and the unfair trade practices and false or misleading advertisements that are opposed to the interest of the public and consumers, and to promote, protect and enforce the rights of consumers as a class. Composition of the Central Authority. The Central Authority, as per the law, shall consist of a Chief Commissioner and such a number of other commissioners as prescribed to be appointed by the central government to exercise the powers and discharge the functions of this Act. Furthermore, the headquarters of the Central Authority shall be at such place in the National Capital Region of Delhi, and it shall have regional and other offices in any other place in India as the central government may decide. In the case of Motilal Yadav versus Shri Rajiv Gauba, Cabinet Secretary 2024, the applicant submitted to the court that some prominent persons of the country who are holders of the highest national civilian awards, Padma Vibhushan, Padma Shri, and National Filmfare Awards, in violation of the provisions of the Prohibition of Advertisement and Regulation of Trade and Commerce, Production, Supply and Distribution, Amendment Act 2020, are participating in endorsements and advertisements of cigarettes and tobacco, etc. Aggrieved, the applicant filed a public interest litigation before the writ court. The division bench of the writ court disposed of the said petition with the liberty to the applicant for making appropriate representation before the competent authority for framing of the guidelines. He was also directed to make a request to the central authority for redressal of the grievances relating to the violation of consumer rights, unfair trade practices, false and misleading advertisements under the Consumer Protection Act by approaching the Central Consumer Protection Authority. The writ court also directed that in case the petitioner approaches the aforesaid authority, his grievance shall appropriately be attended in accordance with the law. Dear viewers, now we shall discuss the powers and functions of the Central Authority. The Central Authority shall protect, promote, and enforce the rights of consumers as a class and prevent violation of consumer rights under this Act. It shall prevent unfair trade practices and ensure that no person engages himself in unfair trade practices. This authority shall also ensure that no false or misleading advertisements are made of any goods or services that contravene the provisions of this Act or the rules or regulations made thereunder, and ensure that no person takes part in the publication of any advertisement that is false or misleading. The Act further provides that, without prejudice to the generality of the provisions contained in this provision, the central government may, for any purposes aforesaid, inquire or cause an inquiry or investigation to be made into violation of consumer rights or unfair trade practices, either suo motu or on complaint received or on the directions from the central government. It can also file complaints before the district commission, state commission, or the national commission, as the case may be under this Act. It may intervene in any proceedings before the district commission or state commission or national commission, as the case may be, in respect of any allegation of violation of consumer rights or unfair trade practices. It can review the matters relating to and the factors inhibiting enjoyment of consumer rights, including safeguards provided for the protection of consumers under any other law for the time being in force, and recommend appropriate remedial measures for their effective implementation. The central authority may recommend adoption of international covenants and best international practices on consumer rights to ensure effective enforcement of consumer rights. It will also undertake and promote research in the fields of consumer rights and spread and promote awareness on consumer rights in our country. The authority may encourage non-governmental organizations and other institutions working in the field of consumer rights to cooperate and work with consumer protection agencies. It may foster the use of unique and universal goods identifiers in such goods as may be necessary to prevent unfair trade practices and to protect consumer interests. It may issue safety notices to alert consumers against dangerous, hazardous, or unsafe goods or services. It may advise the ministries and departments of the central and state governments on consumer welfare measures and issue necessary guidelines to prevent unfair trade practices and protect consumer interests. On 30th November 2023, the Central Consumer Protection Authority notified the guidelines for prevention and regulation of dark patterns 2023 to prevent unfair trade practices. Dark patterns mean any practices or deceptive design patterns using user interface or user experience or interactions on any platform that are designed to mislead or trick users into doing something they do not want to do. Dark pattern is a way of misleading which is done by subverting or impairing consumer autonomy and decision making, which amounts to misleading advertisements or unfair trade practices in violation of the consumer rights. To cast the net fairly wide, these guidelines apply to all platforms that offer or sell goods or services. The guidelines further state that every person who is included in any platform is prohibited from engaging in dark patterns, and in case of any ambiguity or dispute in interpretation, the decision of the Central Consumer Protection Authority will be final. In the case of Pankaj Chandokia versus the Coffee Bean and Tea Leaf 2023, the complainant had stated that immediately upon issue of the bill by the opposite party, the complainant received another message on his mobile stating that the loyalty wallet of the complainant had been successfully loaded with 19.15 loyalty points, which would expire on 3/11/2023, and the loyalty wallet balance was 19.15. The complainant stated that such messages violated consumer rights as they amounted to dark patterns, which are looked down by the Government of India, and the government says that no person, including any platform, shall engage in any dark pattern. The Commission held that the opposite party has to immediately delete the personal information of the complainant from the electronic database whenever reflected in the records and not to indulge in unfair trade practices and dark pattern practices. Now we shall discuss the powers of central authority to refer matter for investigation or to other regulators as per section 90. The central authority may, after receiving any information or complaint or directions from the central government or on its own motion, conduct or cause to be conducted a preliminary inquiry as to whether there exists a prima facie case of violation of consumer rights or any unfair trade practices or any false or misleading advertisements by any person which is prejudicial to the public interest or to the interest of consumers, and if it is satisfied that there exists a prima facie case, it shall cause an investigation to be made by the Director General or by the District Collector. The section further states that where, after preliminary inquiry, the central authority is of the opinion that the matter is to be dealt with by the regulator established under any other law for the time being in force, it may refer such matter to the concerned regulator along with its report. For the purposes of investigation under this provision, the central authority, the Director General, or the District Collector may call upon the person referred to above and also direct him to produce any document or record in his possession. Power of central authority to recall goods, etc. The Consumer Protection Act 2019 provides that when the central authority is satisfied on the basis of investigation that there is sufficient evidence to show violation of consumer rights or unfair trade practices by a person, it may pass such order as may be necessary, including the recalling of goods or withdrawal of services that are dangerous, hazardous, or unsafe, reimbursement of the prices of goods or services so recalled to purchasers of such goods or services, and discontinuation of practices which are unfair and prejudicial to consumer interests, provided that the central authority shall give the person an opportunity of being heard before passing an order under this provision. Now we shall discuss complaints to authorities. Under section 17 of the Act, a complaint relating to violation of consumer rights or unfair trade practices or false or misleading advertisements which are prejudicial to the interests of consumers as a class may be forwarded either in writing or electronic mode to any one of the authority, namely the district collector or the commissioner of regional office or the central authority. The district collector may, on a complaint or on a reference made to him by the central authority or the commissioner of a regional office, inquire into or investigate complaints regarding violation of rights of consumers as a class on matters relating to violations of consumer rights and unfair trade practices, false or misleading advertisements within his jurisdiction, and submit his report to the central authority or to the commissioner of the regional office, as the case may be. Next, we shall discuss power of central authority to issue directions and penalties against false or misleading advertisements. As we all know that advertisements play a major role in consumer awareness and sales promotion. However, false, misleading and deceptive advertisements may mislead the customers. Hence, the central authority has immense powers in this regard. Where the central authority is satisfied after investigation that any advertisement is false or misleading and is prejudicial to the interests of the consumers or is in contravention of consumer rights, it may, by order, issue directions to the concerned trader, manufacturer, endorser, advertiser, or publisher, as the case may be, to discontinue such advertisement or to modify the same in such manner and within such time as may be specified in that order. Notwithstanding the order passed as above, if the central government is of the opinion that it is necessary to impose a penalty in respect of such false or misleading advertisement, it may, by order, impose on the manufacturer or endorser a penalty that may extend to 10 lakh rupees, provided that the central authority may, for every subsequent contravention by the manufacturer or endorser, impose a penalty that may extend to 50 lakh rupees. Furthermore, where the central authority deems it necessary, it may by order prohibit the endorser of a false and misleading advertisement from making endorsements of any product or service for a period that may extend to 1 year, provided that the central authority may, for every subsequent contravention, prohibit such endorser from making endorsements in respect of any product or service for a period that may extend to 3 years. Where the central authority is satisfied after investigation that any person is found to publish or is a party to the publication of a misleading advertisement, it may impose on such person a penalty that may extend to 10 lakh rupees. No endorser shall be liable to penalty under this provision if he has exercised due diligence to verify the veracity of the claims made in the advertisement regarding the product or service being endorsed by him. No person shall be liable to such penalty if he proves that he had published or arranged for the publication of such advertisement in the ordinary course of his business, provided that no such defense shall be available to such person if he had previous knowledge of the order passed by the central authority for withdrawal or modification of such advertisements. Dear listeners, while determining the penalty under this provision, regard shall be had to the following, namely, the population and the area impacted or affected by such offence, the frequency and duration of such offence, the vulnerability of the class of persons likely to be adversely affected by such offence, and the gross revenue from the sales affected by virtue of such offence. Keeping in mind the principles of natural justice, the central authority shall give the person an opportunity of being heard before an order under this section is passed against him or her. Now we shall discuss certain relevant sections from the Consumer Protection Act. Section 22 of the Act deals with search and seizure. For the purpose of conducting investigation after preliminary inquiry under Section 19, the Director General or any other officer authorized by him in this behalf or the District Collector, as the case may be, if he has any reason to believe that any person has violated any consumer rights or committed unfair trade practice or causes any false or misleading advertisement to be made, shall enter at any reasonable time into any such premises and search for any document or record or article or any other form of evidence and seize such document, record, article, or such evidence, make a note or an inventory of such record or article, or require any person to produce any record, register, or other document or article. Furthermore, the provisions of the criminal procedure law shall be applicable in case of the search and seizure made under the Consumer Protection Act. The Act further provides that every document, record, or article seized under this section or produced under this provision shall be returned to the person from whom they were seized or who produced the same within a period of 20 days of the date of such seizure or production, as the case may be, after copies thereof or extracts therefrom certified by that person in such manner as may be prescribed have been taken. When articles seized under this provision are subject to speedy or natural decay, the Director General or such other officer may dispose of the article in such manner as may be prescribed. Section 24 states that a person aggrieved by any order passed by the central authority under sections 20 and 21 may file an appeal to the National Commission within a period of 30 days from the date of receipt of such order. Section 25 of this Act deals with grants by the central government. The central government may, after due appropriation made by Parliament by law in this behalf, make to the central authority grants of such sums of money as that government may think fit for being utilized for the purposes of this Act. Dear viewers, Section 26 deals with accounts in audits. It provides that the central authority shall maintain proper accounts and other relevant records and prepare an annual statement of accounts in such form and manner as may be prescribed in consultation with the Controller and Auditor General of India. The accounts of the Centre Authority shall be audited by the Controller and Auditor General of India at such intervals as may be specified by him, and any expenditure incurred in connection with such an audit shall be payable by the central authority to the Controller and Auditor General of India. The Controller and Auditor General of India or any other person appointed by him in connection with the audit of the accounts of the central authority shall have the same rights, privileges, and authority in connection with such audit as a Controller and Auditor General of India generally has in connection with the audit of the government accounts, and in particular shall have the right to demand the production of books, accounts, connected vouchers, and other documents and papers, and to inspect any of the offices of the central authority. The accounts of the central authority, after proper certification, shall be forwarded annually to the central government, which will cause the same to be laid before each house of the parliament. Section 27 deals with the furnishing of annual reports. The central authority shall prepare once in every year in such form, manner, and at such time as may be prescribed an annual report giving a full account of its activities during the previous year and such other reports and returns as directed, and copies of such reports and returns should be forwarded to the central government. A copy of the annual report received as above shall be laid as soon as possible after it is received before each house of the parliament. In the end, I would like to say Today, the market is flooded with a plethora of goods and services. International dimensions and globalization have led to the emergence of global supply chains, the rise in international trade, and the rapid development of e-commerce have facilitated new delivery systems for goods and services, and diverse options are available to the consumers. On the flip side, the consumer has also become more vulnerable to new forms of unfair trade practices and unethical business practices. Misleading advertisements, telemarketing, multi level marketing, direct selling, and e commerce have led to new forms of challenges. In this regard, it is important to note that the Central Consumer Protection Authority, as holistically discussed in this lecture, has a very crucial role to play in ensuring protection, promotion, and enforcing consumer rights. The powers vested with the central authority are indeed very wide, which includes the power to investigate, search, seize, pass appropriate orders, recall the goods as well, and issue directives and impose penalties for false or misleading advertisements. In the end, I would like to conclude by saying that the Central Consumer Protection Authority plays a very important role in upholding the concept of consumerism in our country. With this, we come to an end of today's lecture. Thank you very much.